Okay, in this video, we're just going to finish off the last worksheet, which is to have a quick look through the issues of removing a company. Now, when we talk about removing a company, there are really two major distinctions to make. One is a company which is solvent and has simply finished its business and now wants to move on to other things, what the shareholders do. And the second is a company that doesn't have the money to pay its creditors, and so the assets of the company need to be cashed up or liquidated is a proper term, and the money distributed to the creditors and then to the shareholders if there's anything left over. So we had a look at some of these companies earlier, or examples of the same things. Bob's Heat Pumps Limited, odd job, Bob Limited. If you look at that company by searching it, you're going to find there's no documents. So we've talked about this, that the registrar has removed the company. If we look at Dundee and Developments Limited, this is a company that has been removed from the register. Where are we? Removed from the register, or struck off. Now, Dundee Developments now grayed out because, of course, the status is removal. Now, it's a very straightforward small company. Obviously, it's had one shareholder, one director, and now it's been removed. Now, this particular person has followed what is the correct procedure, which is a request for removal. So they have filed a document to ask the registrar to remove their company from the register, and that means it's struck off. And they have followed the proper procedure, which I'm just opening up now. Now, that procedure is to fill in a form and request the registrar to remove the company. It's done by a shareholder, Robert George Burns. I'll call him Robbie Burns. And he's been authorised by a resolution, and since he's the only shareholder and director, he had a resolution with himself and signed it. The grounds: the company ceased to carry on its business, paid all its creditors, and distributed surplus under the Constitution and the Companies Act. Companies Act, look at the 7th schedule to the Act, and it shows the order in which company assets must be distributed. So he's also got a notice from the IRD saying that they're happy the company be removed, and he's concluded his resolution of his company. So those are the two documents we have to do. He signs it, dates it, and that is an offence to falsify these documents, and you could certainly be sued for doing so, or prosecuted as well. So here we have the letter from the Inland Revenue. You apply to IRD, say you want to deregister a company. They confirm there are no tax obligations outstanding and send a letter. You attach with it your resolution of the company, so that the company, through special resolution, remember that's 75% vote minimum, under section 318, has resolved to request and has authorised Robert George Burns to make applications signed by the shareholders, Robert George Burns. Okay, now this is the proper way to do it, and it's particularly important with the IRD because once this is done, then you cannot have further issues relating to tax unless you are fraudulent in your statements. Now, that's a very good example of what you should do. The only way you can do this, though, is if you're solvent, because you have to say you've paid everybody off and IRD is happy with that. Now we need to look at situations where the company perhaps cannot pay its creditors. Now, just a quick note about the appointment of liquidators. A company can appoint a liquidator when it is solvent, and the liquidator can go through the full process of liquidation. If there are complex business issues involved, this is the correct way to do it, even if the company is solvent. If there's not, and you just pay everybody out, do what Dundee Investments did, or Developments did. Right now, we're talking about insolvent companies who cannot pay their creditors, and so the creditors want the company liquidated and to get as much money out as they can. The second situation here is where you have secured creditors. Those are creditors who have a right to take assets to secure their specific debts. This is very common with banks to take the right over a company to sell its assets, and the way they do it is to take control of the company and manage it and run it so they can collect accounts receivable, complete unfinished contracts, and sue people who haven't paid the company. the person they appoint is called a receiver. And you'll see that when you look at this explanation of receivership. And we can go further into this in class if necessary. So the receiver is there for a specific creditor, be it the bank, be it a holding company, and you'll see that with the Shanton examples. Whereas a liquidator is there to liquidate all the assets, then to pay out according to the 7th schedule all the creditors they can. Firstly, the secured creditors, if there's no receiver already doing that. And then they pay what are called preferential creditors, such as employees up to the point of receivership or liquidation, IRD, and various other taxes, after which they pay unsecured creditors and then shareholders and deferred payments. You'll see this list, and we don't go into this in a great deal of detail. There is this ability to negotiate compromises or voluntary administration. And again, we can explain this in class if people have questions. But it's really just getting into a deal with your creditors where they agree to take less than they're owed so the company can continue to trade. So you may ask the creditors to give up some of their debt or to defer payment of some of their debt until a later date. Shanton is an excellent example of this, which went into receivership and liquidation recently. So if we just go back and have a look at Shanton, just get rid of some of these things. So we'll put the Shanton group in and do a search, and lots of companies come up here. So Shanton Limited, you'll see here, is trading. It's just happily going along. It may well have been the holding company and not owed money to anyone. Shanfash Limited is in liquidation. Shanton Apparel has already been removed after a receivership. Shanton Retail Limited is in receivership. This one's still going along. And this one's also in receivership. So let's just pick any of them in receivership to start. How do we know they're in receivership? Well, because they have to have this in their name and in all communications. This is under the Receiverships Act 1993, which covers all receivership issues. Liquidations issues are in the Companies Act from Section 240 onwards. So a lot of documents. And what we find in those documents is that after the appointment of a receiver, which is here, and it tells us who the receiver is, the receiver has to make a series of 6 monthly reports, and when they're finished, they're going to do a final report. But quite clearly, you're going to know a company's in receivership. So we can find out who the receiver is and talk to them. So it's Anthony Charles Harris, accountant presumably, can't be a lawyer because they can't be in companies, and they are conducting business as Anthony Harris Limited, and he's from Taronga. And so you can have a look at any of these reports, and they're going to simply tell you what's been happening, how much they've sold, and how much they expect to receive. So they put in a statement of affairs, what property they're disposed of, who's unpaid, how much money is available to pay them, and their current receipts and payments. So if you bring this up and just read through it, you'll get a good feel of it. So secured parties, the parent company, which is loan money, it's 7.2 million there. Preferential creditors and unsecured trade creditors. So these are all debts. So this is what they're doing. They're collecting accounts receivable, dealing with shares and subsidiaries, because if the company in receivership owns other companies, that's an asset. Okay, so have a look through these documents. Get a feel for what's in there for both a receiver and liquidator. You're going to see when you look at the, wrong document. You're going to have, when you go through this and look at the liquidators, you see exactly the same thing, a set of reports by the liquidator. The last thing you just want to look at is other databases. So have a look at these lists of other databases. And just be aware that there are many ways to find things out about companies, about the people you're dealing with, about other entities. So you can see you can find out if auditors are in fact registered. We have cooperatives, we have incorporated societies, limited partnerships. Right, so you can search all these registers, have a look at a few of them, and we can talk about them. The other one down here is the insolvency register. So you can go through here and you can look up a person's name, So I'll just pick up a common name, hopefully not someone we're aware of, and be very aware that these are real people and very sensitive issues. So we could bring up someone here. And so it gives the person's adjudication. This was on a debtor's application, so she applied for her own bankruptcy, and it gives the date and when and what court, and you can email the official assignee and talk to them if you need to. If we look at some others, we're going to find out that other people were put into bankruptcy by creditors. So we have someone down here. Also a debtor's application. What you'll see on here is on a creditor's application where a creditor has gone to court and asked the court to put a person into bankruptcy. So bankruptcy is the equivalent of liquidation, except of course we don't strike people off. They stay in bankruptcy for 3 years, after which they are released from most of their debts. It doesn't include debts such as fines and family issues such as child support. Okay, so have a look through that, and as I said, be careful that you don't cause anybody problems. If you see someone whose name you know, then just keep quiet. Okay, so we'll end there.